My name is Caleb Alexander-McKinzie. I am an attorney with the Arkansas Municipal League. If you don't know what the Municipal League is, we are an organization. We're created by cities and towns. They put their money together to provide themselves services. Good chance we cover your health insurance, right? Good chance we cover your civil defense and in cases where the city gets sued. We have a work comp department, and we also have me. I'm the inquiry attorney. So everybody who's in our program, if you're a city official or a city, you have the right to call me and ask me general legal questions, and I will hopefully give you the right answer. But the other part of my job is I get to travel around the state and I get to talk to folks like you, the folks who work for our cities and towns, the folks who make sure that our water is clean, that our streets are safe, that our communities are functional. And I appreciate what I do mainly because I appreciate what y'all do. Right? It keeps my family safe in Little Rock where I live, keeps my family safe in the hometown I grew up in out in Prairie County, real small town. So whether we're talking about the smallest towns in Arkansas or the biggest towns in Arkansas, the best part of my job is working with you folks. And I don't say that lightly. It's not something I say just to, get you guys excited about what you do, right? You know what you do. But why we are here today is to talk about the FOIA. And so if you don't know what the FOIA is, you should. But in a nutshell, the FOIA is this kind of what we call our sunshine law. And we're going to talk about what that is. And it covers a couple different parts, right? It gives citizens the right to request documents that are in existence. It also makes sure that citizens have the right to be in public meetings. And it says what a public meeting is. And we're going to cover all of those things. I've been told that I've got about an hour and a half to talk to you fine folks, which is more than enough time. It's going to run us right up until about lunchtime. And I'm going to get you out of here by lunch, mainly because most of the folks in here have guns and I don't. So I don't want to stand between them and the meal line. So just before we kick off, I just want to say thanks for having me. If nothing else, I appreciate y'all letting me come here. Came through early this morning, got a good cup of coffee from a local brewery, coffee brewery downtown, and saw an old friend of mine that I have not seen in years that I did not know works there. And I am convinced that Arkansas is just one big small town. And so, all right. So before we get started really into the details, there's a couple of things I want to make you guys aware of, right? A couple of tools that we've built. The Municipal League has put together something that we call the Civilpedia. And for a lot of you folks, this will not necessarily be handy to you other than the fact it does have a big section on the FOIA. And we've written this, we've kind of combined all the laws and put it down into language that everybody can understand. And we've created kind of a textbook on municipal law, right? So everybody in Arkansas can read it. You don't have to have a PhD to understand it. We walk through everything from, like I said, the FOIA. We walk through HR law. We walk through, how to do your budgets in your cities and towns. What do you do if a board member resigns? Those kind of things, different forms of government. It's very handy. And there's also, I want to make you guys aware of, we just got out of a legislative session. They are no longer in session. A lot of people applauded for that. But there's no new laws being passed. But they did pass a new law. Then it's Act 505 of 2025, not 2015. And so what this did is it kind of changed some of the FOIA language. It has not gone into effect yet, but we're going to talk about some of those changes. Most of those changes were made into the parts of that the law that cover our open public meetings. And so that's important. It applies to places like this when you have multiple officials get together, but doesn't really apply to records. But a lot of what we're going to talk about is just the records. So I mentioned a while ago that the FOIA, the Freedom of Information Act, this is our sunshine law. It's all states kind of have one. The federal government has one. Again, it covers a couple different topics. I really like this quote from Justice Brandeis. He was, born in 1933. He was a U.S. Supreme Court justice. If you don't know that, he had this quote that's fantastic. Sunlight is said to be the best disinfectant. If the broad light of day could let in upon men's actions, it would purify them just as sun disinfects. That is the purpose of the FOIA, right? That's the reason we make these records and the legislators made these records open to the public. The idea is that we want to prevent government corruption, right? We want to make sure that that we're upfront, we're honest, we're transparent, that whatever our government is doing, the people know about it within reason, right? There's some caveats that we're going to talk about. Also, make sure that citizens have the right to go to our public meetings and hang out and see what their legislatures or their local legislatures are debating and stuff like that. It is a vital and important part of our democracy, and that's kind of what the legislature said. If you look at Arkansas Code 2519-102, the legislature basically said that we want to keep our democracy, right? We want to make sure that the citizens know what we're doing. We keep the public trust. Now, I'm a very, very big advocate of the public trust and a number of reasons. And kind of what that means is that we're all in positions that we're in because the public allows us to be, right? My salary is paid through tax dollars to some degree. A lot of yours are as well. Our cities are ran where they're governed by the people for the people, right? We hold those kind of things self-evident that this is the system of government that works best. There's a quote from, I forget who said it, but they said democracy is the worst form of government in the world other than all the rest of them, right? It's the one that seems to work best and has worked really well for us for a couple hundred years now, about 250 of them. And kind of like to keep it intact and keep it around. We can't do that if we lose the public trust, right? We operate as a government on a philosophy called consent of the governed. Has anybody ever heard that phrase before? Consent of the governed. That means that if we're not doing what the governed, what the populace wants us to do, they'll vote us out of office. They'll vote to underfund us. They will not pass sales tax so we can do our jobs, right? They will get rid of us effectively, and they'll maybe reincorporate another government or do something else. We've got to keep that public trust. It's very, very, very important for us, for you, for me to be able to do our jobs. If we don't have the public trust, we can't really function. Now, in saying that, I do want to say that our position at the Municipal League, my position, is that we kind of agree with Justice Brandeis. I like the FOIA, right? I think the FOIA is very important. But I also want to acknowledge that I work for government employees. I get the phone calls from government employees. And I know full well, just like you do, that sometimes the FOIA is used in ways that it was not meant to be used. It is used to be harassing of government officials, right? I have seen this law be used by individuals to functionally shut down a local government. The local government can't go fill in the potholes. They can't put staff making sure our water is clean. They can't put folks like you on the streets to make sure we're safe, because they have to put all hands on deck going through years and years and years and years worth of documents that person will get, throw in the trash, and then give you another FOIA, right, to look for things. So it's not without its flaws, but it is still vitally, vitally important. So what I want to do here today, and what I hope I convey to you all, is that we don't need to look at the FOIA like this enemy. It can be a headache, but it's also vitally important. It's a vital, important part of our jobs. We just have to know how to navigate it. And from what I've found, from my experience, that when we know how to navigate the FOIA, when you know what is releasable and what is not releasable, when you know how to talk to the community, when you know kind of what they're doing, when the person who's committing who's submitting the FOIA request, when we know what they're after, we know kind of where they're coming from, that makes it easier for us to give them what they want, right? It makes it easier for us to communicate with them. And communication is a vitally important part of what it takes to make sure that we're following the FOIA. So again, we looked at that. We saw the legislative intent. We saw this kind of sunshine effect. I'll just breeze through this. Public business needs to be performed open in a public manner. I think that's a good idea. Electors need to be advised of the performance of their officials so that they can kind of judge and know who to vote for. We don't want people continually to vote somebody in just because they've been there the whole time. We want people who are good at their jobs, who are competent to be in office. That makes sense, right? Right. We all kind of understand that. And we want to know that the electors kind of know our decisions, right? Why they made the decision, what the communication was in going to that, and what they're doing. When we pass ordinances, we have a rule that they have to be read 3 times at 3 different days. That gives people a chance. This was written back in the horse and buggy day, where everybody couldn't drive to the local court, or, to the local city hall to sit on every public meeting. But it gave folks a chance to hear what was being passed. So they would read the ordinance out loud. They'd tell people why they were doing it. They'd debate it. Next month, they'd do the same thing. It's changed a little bit, right? We all have cars now. I don't own a horse. I don't saddle him up, and I didn't ride here on one. Family still has a lot of them, but we've got vehicles now. We've got the internet now that's completely changed the way that we can do things. It's kind of just completely and totally morphed our ability to communicate with one another. The internet's just like, you're not happy with the world today, or you're happy with the world today. There's a good chance it's because the internet exists. And so it's kind of morphed that. And so we have a way we can vote not to do those readings. We can change it. We can only read it once. Do a lot of things. But the whole idea there is so that we can tell people what we are doing and why we are doing it. So again, the FOIA has 2 focal points, right? There's about 12 different statutes that cover the FOIA, but basically they boil down into 2 different things, right? Request for public records and our open public meetings. That's simplifying it, though. There are hundreds upon hundreds of FOIA court cases. There are very nuanced portions of the law. As we will see, there are things that are considered non-disclosable that we have to redact in our public records. There are things that are not considered public records that you might think, well, this was made by a government and it's discussing governmental things. We have to release this. Statutes will say that, hey, that particular document, not a public record at all. You do not give this to anybody. It's confidential. So we're going to talk about a few of those things. Other part of this, like I said, public meetings. What constitutes a public meeting? Is every gathering a public meeting? All right, no, this it's not a trick question. The answer is not every gathering of public officials is a public meeting. Very important definitions, and knowing those definitions are key. The state, and we help with this, but the state has made this really cool little FOIA handbook that's available online. It has all the statutes. It's got a whole lot of important attorney general opinions. It's got a whole lot of important case law that the Supreme Court, Arkansas and above have kind of put out. Hits on a lot of topics, right? I keep this thing on my desk every day, and I use this every day to help answer my questions from folks just like you who call me and ask me. They can give you a copy of it that you can keep in your squad cars, that you can keep on your desk. They have a digital copy of it. I'm telling you, don't sleep on this thing because it's vital information. It's very, very, very good at what it does. And the more you know, the better off you're going to be. So go check that out. And you're going to want to know those things. I'm going to go ahead and get to the bad part first, because what happens if we violate the FOIA? Well, you might get sued and have to come listen to some yuppie from Little Rock give you a speech on a Thursday morning, but there can be criminal penalties. It's a Class C misdemeanor if you negligently violate the FOIA. Now, negligent, well, you folks on this side of the room, I think y'all probably know what negligence is, but for the folks who haven't been to law school or aren't in law, negligence is not intentional. It's an oopsie daisy, right? I accidentally did this. I didn't mean to. Wasn't malice behind it. I missed something. It was my fault, but I missed it. I ran into you at the red light negligently. I wasn't aiming for you. I just wasn't paying attention, right? That's negligence. You can still catch a Class C misdemeanor for negligence if you violate the FOIA. Take a look at 25-19-104. It talks about that. There's also these kind of what I call civil considerations, right? You can get sued, and being sued is not fun. Now, most of you, if you do get sued from the FOIA, it will not be in your personal capacity, but it could be. A lot of times it's a lawsuit against the city. Still, it's going to cost you money, right? It's going to cost the taxpayers money. It's going to cost the city money. And with the FOIA, importantly, we think about lawsuits, generally speaking. I know your father, so I'm going to pick on you a little bit. Say me and Mr. Albright here, we get into it over a land dispute. He's had his yard redone and all that water's flowing into my yard. And so I sue him for a trespass or something, civil case. I file the lawsuit. He's got 30 days to respond. Then we get into discovery. We might settle. If you get sued on FOIA, the law allows you to ask for an emergency hearing within 7 days. That's not a lot of time, right? Because that means you're getting served with the lawsuit. You've got 7 days to go get with your city attorney, find the documents that you need, figure out what's going on, figure out your best argument to the judge, find out how you didn't violate the FOIA, or maybe you did violate the FOIA, or maybe you are working in those parameters and you're still working on it. And so you have to figure out your case really quick. So you can say, hey, judge, we're not complying with this. They asked for 17,000 records, and it's been 2 days, right? We've got a stack of papers. They can come get it now, and we'll talk about how long you have to do that. But that's the kind of stuff that we're looking at, and you've got to figure that out in 7 days, right? So it's very important for your own just for your own measure to be able to understand how you're doing, that you understand these laws. And even if the judge is like, hey, they've partially, complied, they didn't do everything right, that judge is still possibly going to give that other attorney's fees. I was in a case for another city, it was about a year and a half ago, and they were asked for voluminous records. It was such a big thing. I talked to our boss, Mark Hayes, and I said, man, they've got 2 people who work in this office, and they've got the front door locked. They need help. Let me go down there. And I did. I went down there for a week and stood over a copy machine and had a black marker and redacted stuff for an entire week and made thousands of copies. Then we went to court. I made sure the person had everything that they had asked for that we had. The judge said, sounds like you've complied. And then he gave that attorney's fees, about $1,200. Not the end of the world, but that town could have used that $1,200 for a lot more stuff. So they can get attorney's fees for that. And then last but not least is kind of these social and political ramifications, right? What's the first thing that you hear whenever, if you've told somebody, we don't have any records that are respondent to your request? And even if you haven't heard that, what do you imagine the first response to that is? I heard somebody say something in the back. What was it? Corruption. What are you guys hiding? That's bull crap. I know it. How many of you are actually lying when you say, no, nobody's lying? You're not lying. Hopefully you're not lying about these things, right? Sometimes you don't have records, right? Sometimes if it's taking you a lot longer to get the records, that's exactly what you're going to hear. Oh, they're hiding things. When in the actuality, and I say this from my personal perspective and personal experience, what's mostly happening is there are people still going through hundreds of thousands of emails or going through all of your minutes from your meetings or trying to find things. They just haven't found things. Or the records weren't required to be kept and there's no reason to keep them, just collecting dust. So they've gotten rid of them. All right. Doesn't mean they didn't exist. Just doesn't mean they exist anymore. That kind of negative press, that negative connotation is damaging to our cities and towns' reputation, right? We want to keep, again, governed by the governable, right? We want to make sure people continue to know that they can come to our government and they can trust our government, that we're going to do what we do, right? That we're going to do what they want us to do and that what we need to do, that it's a government of the people and for the people. That public trust is important. And then one of the biggest ones too, that really comes into our boards or our governing bodies, if they do not follow the law, the FOIA, when we have our public meetings and things, maybe they didn't hold a vote right. Maybe they didn't have the recording going. Maybe they got together. It was an emergency. A dam broke. There was water everywhere. They called each other real quick. Let's have a public meeting. 20 minutes later, they show up. They take a vote. They vote to do something. Well, that would actually violate the law, even in cases of emergency. You got to give the press 2 hours notice, yada, yada, yada. We'll cover that in a minute. But the court might come back and say, well, you didn't follow the right procedure. And so therefore what you did is invalid. Or maybe you voted in what's called an executive session off the record. Well, that vote doesn't count. You didn't ratify it on the record, right? They can invalidate your decisions, right? And then you've got to go through all the rigmarole and work again. And it might not work out the same way it did next time. Somebody might have changed their mind. They might have had something going on. So those kind of social and political considerations are something you also have to keep in mind. Just because you want to keep the public trust and you don't want to have to do, I hate redundant work. How many of you guys and ladies like doing the same work twice? I don't. It is my pet peeve. Before I started wearing this monkey suit, I can't stand it. I was an iron worker, built high rises and power plants for years. I'm much more comfortable with a sledgehammer and a couple of spud wrenches on my belt than I am in this thing. But I hated doing double work, man. If somebody came along, the bolt crew came along and messed up something I did when I was a connector, I'd chew them out. I cannot stand it. I don't like doing double work, and I got a feeling that most of y'all don't either. So if we do it right the first time, we don't have to worry about doing it right again. And that's kind of that political consideration. So let's get into the boring part. Let's talk about the law. So I mentioned a while ago that the FOIA, all of these kind of 12 statutes that you can find in 25, 19, 101, et sec. Et sec just means it's a Latin phrase for in sequence. It just means and all the rest of them. So that's where you're going to find all these. And 103 has a lot of definitions, and you're going to see some of these, right? What is it? What is a custodian of a record, right? It's not the person who's sweeping in City Hall. Custodian of the record is defined. It's the person who has administrative control of a public record. What does administrative control mean? We're going to talk about that, right? Just because you might have it, maybe Leg Audit's got some of your documents. They're not the custodians of those records if they've got them. You're still the custodian. Maybe I know you guys have Brian Albright, a fantastic city attorney, but a lot of cities and towns have contract city attorneys, and they may have some documents because they're looking at it to help with a case or to figure out how to do an ordinance, and somebody FOIAs it. Well, that guy went on vacation. City's still the custodian of those records, right? Your police department could be the custodian. Your city clerk could be the custodian. The city as a whole can be the custodian. Very important. Not all records are public records. We talked about this in a minute. Public records are defined as writings, recorded sounds, films, tapes, electronic or computer-based information, data compilations that are in any medium that are required by law to be kept or otherwise kept, even if it's not required to be, that constitute a record of the performance or lack of performance of official functions that are or should be carried out by a public official or employee, a governmental agency, or any other agency or improvement district that is wholly or partially supported by public funds or expending public funds. Sorry, I don't have that memorized. I absolutely read that off the screen. So that's a lot. That's a big definition. There's a couple things to break down, and we'll break that down by piece here in just a little bit. And then over here, I mentioned a while ago that not every meeting is a public meeting. Public meetings are defined. It's defined as a meeting of any bureau, commission, or agency of the state or any political subdivision of the state, including municipalities and counties, boards of education, and other boards or bureaus, commissions, or organizations. So that's what a meeting is going to be. Now, there used to be some language, and we'll talk about how the law has changed, and said this is all informal or formal meetings. And for a couple of years, I've been telling folks, I know you guys have a board of directors. You're under the city manager form of government. Vast number of cities and towns in Arkansas are under what we call the mayor council. They got a mayor, they've got a city council. And for years, the rule was 2 or more city council members couldn't get together and talk about anything regarding public business because that would violate the FOIA unless they called a special meeting. The law has now changed, and we'll talk about some of those changes. And even if you guys are not managing or handling public meetings, it's still important for you to know, especially you guys, because y'all might get called to get enforced law, and you need to be able to say, hey, here's what they did. We've spoken to the city attorney. Our opinion is that the law was or was not broken, right? So this is not actionable, or maybe it is actionable, but you don't know that unless you know the nuances and kind of those definitions that are in the law. So the first part of this is public records, right? The first 2519-105 covers examination and copying of public records. Statute says that unless specifically provided otherwise, all public records shall, and shall is mandatory, it's not optional, shall be open to inspection for copying by any, open to inspection and copying by any citizen of the state of Arkansas during regular business hours of the custodian of the records. So your cousin up in Missouri, does this apply to them? Do they have FOIA rights in Arkansas? No, they don't have a right to it, right? Arkansas citizens, regardless if they live in Hot Springs or not, they have a right to ask you for your public records if they want to know something. We see a lot of this. Dem guys up in Little Rock may very well FOIA people in Hot Springs or people in South Arkansas for stuff. They're citizens of Arkansas. They have that right. So let's kind of break down, again, this record, right? What is a public record? Well, there's a very broad definition. I think it breaks down into 4 parts really easy. Writings, recorded sounds, films, tapes, or data compilations in any form. They're recording this back there. Good chance that recording is FOIable, is FOIable, right? Somebody can ask for it. And we're going to make it available to anybody who wants to watch it anyway. I'm a big fan of transparency. So, but that's not a piece of paper, right? But it's a recording. So that's a public record. It can be anything, your emails, transcripts, phone calls. I've got a notepad in there that I've got scribbles on. That can be a public record. These are records that the law says are either required by law to be kept. There are lots of records. I mean, there's a whole section for police records on what you have to keep, how long you have to keep them. But even if they're records that the law doesn't require you to keep, but you have kept, if they're in existence, they very well may be FOIable. They can be released unto public, subject to some things that we carve out. But the big part of this, I've got it highlighted on here, is that these things cover the performance or lack of performance of official functions. So one of the things I like to say to break this down the easiest, this is my cell phone. This is my personal cell phone. It comes out of Caleb's bank account. That's how I pay for it. It's not a league phone. The municipal league does not pay for this. It's totally mine. Full disclosure, I've got text messages with my general counsel, John Wilkerson. He texted me this morning. He was going to be here today. We've got a big convention coming up next week. And he said, hey, if you can handle this, I'd very much appreciate it. I've got 1,000 things going on. We're about to have 1,700 officials converge on us. And he's got to make sure he's got everything in line. Totally understandable. And so I said, yeah, sure. No, I've got it. I've built a PowerPoint. I'm good to go. Don't worry about it. I've got you covered. And he was, great. Thanks. That is about my performance. So even that it's a text message. It's on my personal cell phone, but it's about my job, right? It's about my performance as a public employee. If somebody wants that text message, I have to turn it over to. Now, that being said, this laptop, right? Let's change it a little bit. This laptop is the municipal league's property, right? This is a government laptop. I use it. But let's say that there is for some reason I've gotten into my personal email, my personal Gmail account, and I'm talking about one of the nonprofits that I work with in Little Rock, totally separate from my public work, has nothing to do with it. Curious, how many of you think that that's a public record? We'll take a vote. If you think that it is a public record, raise your hand. Okay. If you think it's not a public record, raise your hand. Okay. I'm going to pick on you. Is that okay? Why do you think that's a public record?
And it is something.
publicly on laptop. That may be the case. If you look over here on section 4, and we'll get that, records that are in the scope of their employment are being kept in a public space, a public office, or a public machine are presumed to be a public record, but that presumption is rebuttable. So for who was somebody who said they don't think it's a public record? Why do you think it's not a public record?
Well, then scope of your duties as a.
That's a very good point, and that's the argument that I would make. Right? That, hey, this, yeah, sure, it's on this laptop and everything, but it has nothing to do with my public job, right? So just because I can access it on this machine doesn't mean it's a public record. I don't have to turn it over. A savvy attorney who's FOIAing me or who wants to see what I'm doing might come back and say, well, that may be the case, but you work from 8 o'clock every day till at least 5 o'clock every day, and I want to know if you're sending private emails and private phone calls while you're on the public's dime. That could constitute a lack of performance. Would it be a public record then? Maybe, right? That's my favorite lawyer answer. It depends, right? Because there's not a real answer. That's what we will quibble about. We'll argue about. But that's when I say this stuff is not cut and dry in a lot of sections, that's the kind of stuff we're talking about, right? Just because it's on a public record or on a public device doesn't mean it's necessarily a public record. It could be. On a private personal device doesn't mean it's not a public record, you know? So if you've got a city issued phone or something like that and you're off work, but your spouse calls you on that number for some reason, maybe your other phone is, I was going to say off the hook, but I think, is that even a thing anymore? People's phones are off the hook. I don't think, yeah. Maybe they can't reach you somehow, so they call your cell phone. Somebody wants to know that, I'd argue for you. I'd say they were off work. That's a private phone call between an officer and their spouse. A city employee and their spouse. That is not a public record. You're not getting that phone call. You're not getting those text messages, and we'll make a judge tell me I'm wrong, right? We'll go to bat for you. The third part of this are records that should be carried out. These records are about things that should be carried out by a public official or an employee wholly or partially supported by public funds or expending public funds. Real simple when we're talking about just us, right? Like people who work for your city and things like that. Does the city of Hot Springs have any public-private contracts? Do y'all contract with private folks? Maybe there's, I don't know, if some smaller towns do this. They make contract with a lawn service to come in and mow City Hall's yard or something like that, things like that. Is that private entity, is that private business person, are they subject to FOIA? Who thinks they are? Yeah, one person. Who thinks they're not? Generally, they are not. Are they subject to FOIA for that government contract? They absolutely are, right? And somebody can FOIA them. I want to know what the government is paying you. I want to know how much you are working and using the FOIA. Yes, sir.
Question on that then. So if they're subject to FOIA, it's only on the terms and agreements and the communication between them and the city, just specifically for that contract, nothing beyond.
If it's in relation with them and another government agency in any capacity, it probably would be, right? But it's got to be in the scope of work for them and whatever contract they have.
Just a department, if they had the one government contract.
That's it, yeah. So they can't, the public cannot come in and say, hey, you've got a contract with the city of Hot Springs. I want to see all of your records, right? They can't do that. It's only within that kind of parameter of their public contract. So important to look at that. And then we talk about this rebuttable presumption, right? All records maintained in public offices or by public employees within the scope of their employment are presumed to be in public record. That presumption is rebuttable. Again, maybe I've got a Christmas card from a family member in my office at work. If somebody wanted to FOIA that, I probably would give it to them just because I don't like to deal with the headache. But if I just wanted to be contentious, I'd say, no, you're not getting that. I'm going to be cranky just like you. Fight me, right? Well, it's in a government office. It's a public record. Well, this is from my great-grandpa in Schenectady somewhere. You're not getting that. Well, it's presumed to be. Yeah, it is presumed, and I am rebutting that presumption. Let's fight about it. Come argue with me. I did not go to law school because I do not like to argue. I went to law school because I like to argue. Let's argue. And I bet I can come out on top on this one. So we talked a while ago about Arkansas citizens being the one that the FOIA applies to. And that's true, right? All Arkansas citizens, no matter where they're at, no matter what city they live in, they are entitled to make FOI requests for public records anywhere in the state. People from Fayetteville FOIA me all the time, right? Northwest Arkansas may FOIA somebody down in Crossett. I've seen that happen, right? there's a missing escapee case going on right now. Former person broke out of jail, was a city employee. I think you all probably have heard about some of this. This person used to be employed by a city in north central Arkansas. Eureka Springs is who it is. And they got FOIA'd yesterday, but they got FOIA'd by ABC's national conglomerate. They lit 30 Rock. They sent them that. And the attorney's like, well, number one, this is not subject to FOIA, but number two, you're not Arkansas citizens. So we're not going to give it to you. Now, just because somebody's not an Arkansas citizen, does that mean that you can't turn it over? No. There's no prohibition against turning documents over if they're otherwise public. You look at it, you're like, well, this doesn't hurt anything to give it over. You can. You're not going to get in trouble if your city policy allows you to. You can give it over if you don't want to, but you don't have to, right? Because there's not an entitlement there. There's also a very particular class of citizen who is not entitled to ask for records under the FOI. And that person is an individual who, at the time the request is made, has either pleaded guilty or has been found guilty of a felony and is incarcerated in a correctional facility. So maybe you were found guilty of a felony and you're out on parole, you're walking around. You can do FOIA requests. Somebody who's done that is walking around and you get a FOIA request, you got to fill it out, right? But if they have pled guilty or have been convicted of a felony and they are incarcerated at the time they make the request, they do not have a right under the law to request this. They need to go through their attorney and go through discovery. Or the second part of this says that unless they don't get it unless the person asking is their attorney, right? If the representative is the person's attorney who is requesting information that is subject to disclosure under this section. So they can go through their attorney to do that. But if you get a letter from the jail, from somebody that you know is in jail for being a felony, and it's just from them, they're pro bono, they want records, cite to 2519-105, find that section and say, nope, the law says I can deny you this if you want to. They give us this right for a reason. So keep that in mind. So IDs. I get this question a lot. Again, almost 500 cities in our program. There's one of me. I work from behind a lot of times. I'm playing catch up, but I get asked by a lot of cities, well, we've got a request. They called it in just over the phone. It's a verbal request. They say they're an Arkansas citizen, but we don't know this dude from Adam. Can we ask for an ID? Can we ask for proof? How many of you think you can ask for an ID? No hand. Nobody thinks you can ask for an ID? Okay. How many don't think that you can ask for an ID? By the way, I won't yell at you for getting a question wrong, I promise. So we got somebody who does think you can ask for an ID. Well, I'll think you can. Oh, you don't think you can? Gotcha. Presumably, yes. Right. And so this is one of those it depends situations, right? There hasn't been a Supreme Court case on this, but in Arkansas, the AG opinions, the Attorney General issues opinions on these things, they're not binding, they're not law, but they're very, very persuasive, right? Courts look at this and they say, well, the Attorney General's office, the Attorney General is the chief law enforcement officer of the state. We think the state hires some of the best legal minds, so we take those opinions and they are governed by the Attorney General. And so those carry a lot of weight. And so the AG has said that, yeah, you can, right? Because the FOIA does provide that requesters have to be Arkansas citizens. It's kind of intuitive that you can ask for an ID, right? Maybe an ID, a record, something showing that they are a citizen of Arkansas. But I want to put a caveat on that. Number one, you can do that. How many think that will be the end of that conversation? It's not going to be, I promise you. Number one, we live in the internet age, as I said, and that's changed everything. I'll step on my own toes here. Last year, I needed to know some information from Alabama, and I'd asked for it politely and was really nice about it and said, hey, I really need this information. Number one, because I was planning something for Alabama, and they still didn't give it to me. So I called up a friend and said, hey, aren't you from Alabama? Yeah. You got family there? Yeah. Give me your brother's number. I need a favor. And I had his brother go through and make the request for me, and I got the information I wanted. It took 15 minutes for me sitting in my desk in Arkansas to find an Alabama citizen. Works both ways. It is not hard for somebody in California, in Oregon, in New York, in Michigan, Mississippi, wherever, to take about 3 minutes out of their life and find somebody who lives in Arkansas who will submit that request. The other part of this is, what are they asking for, right? And is it really that big of a headache that you need to send them back to ask for an ID? You need to call them and have them drive up there, scan something, turn it in. It might be. I'm not saying it's not. It very well could be. But that's kind of dragging this out. It's prolonging it. And it may be the case that it would just be easier on your life and your stress levels if you just said, okay, you're asking for public minutes anyway. There's nothing in there that we need to redact or do anything for. So why not give this over? Or maybe even better, maybe this stuff's already available online on your city website. And if you're not digitizing your records and making them available online, I would strongly encourage you to do so, most of them, right, within reason, because that makes it very simple. Somebody wants to say, hey, I need to review these records. Cool. Here's the HTTP, Hot Springs, Yahoo, whatever. Go search till your heart is just filled, right? If we put all those records online, makes it real easy to say, hey, they're already available to you. You've got access to them. Go right here, find them, right? Then you don't have to go search through a bunch of dusty boxes to find records or emails from 14 years ago or something along that line. It's already done. It's right there. And they can do it from the comfort of their home, right? So think about that. Consider that, though, if somebody is giving you a hard time or if you're asking for an ID. I'm very good friends with the city attorney from Jonesboro, and they do have a policy that they want to know that if somebody is an Arkansas citizen. She's very big on this, and she and I pick on each other a lot. And she does this, right? She says, no, I need some type of proof, right? I need some type of proof that you are an Arkansas citizen. And she gets everything from, okay, sure, to I'm going to sue you. And she says, look, sue me. Sue the city. Like, if you can't prove that you're an Arkansas citizen, then the law is not on your side. Again, depending what the record is, that's going to determine whether or not you want to go through that headache. But you have to consider those things. It may just be easier to go, okay, you sound kind of country, so you're probably from around here somewhere. And you can have the record. Or no, like I need to know you live here. I need to know you live in the state. So just think about that. So we talk about access and format inside the statute. If the citizen wants to request public records, right, the law says the city must allow reasonable access to public records and reasonable comforts and facilities for the full exercise of the right to inspect and copy. And those shall not be denied to any citizen. So reasonable access and reasonable comfort, what does that mean? Right? We've had to kind of look in that law, and there are some definitions of that, but essentially, treat folks how you'd want to be treated. If somebody comes into your office and says, hey, like, I've got nothing to do today, I'd like to look through any emails that you've sent in the last month regarding the watchtower. What I call it the watchtower. What's the tower here called? The Mountain Tower. I'm a comic book nerd, so Justice League, Watchtower, all that fun stuff. I want to see any emails that y'all sent in the last 2 weeks about the Mountain Tower. They planted some new somethings there, and it's pretty. I want to know who did that. Okay, cool. How do you want it? Well, just show them to me. Print them out, and I'll just sit here and go through them. All right, cool. Well, there's a table right over there. We'll get you a nice chair, make you comfortable, right? That's access and comfort. Right? We're going to provide that to them. I just want it in a file, man, or on a PDF, something like that. Just I need access to it. We have to give them reasonable access. Now, I can't come into your office and say, I'm going to sit in your chair, Mr. Albright. I'm going to sit in your chair. I need you to log into your computer for me. I'll tell you what files I want, and you leave your office. Is that going to fly? No, especially because of that badge you got on. But for you other folks who don't carry guns in your day-to-day life, that's not going to fly for you either, right? That's not reasonable, right? Because there's access to records that you have that they don't get, right? So we have to know what they're looking for. We'll talk about how all the records that we turn over need to be reviewed, right? For things that need to be carved out and things like that. That's not reasonable, right? We have to make reasonable access and provide comfort to inspect or copy those records. We also have to make sure that if somebody requests something, it's available in whatever medium or any format that it's readily convertible to. I've got a bank statements are a good example, right? I'm assuming whatever bank you have, they send you a statement every month. Somebody goes through there and reconciles that statement, yada, yada, yada. Somebody wants to view those records, right? Okay, cool. We've got a stack of them right here, just loose papers, everything. Yeah, I don't feel like coming and sitting in City Hall. It's great and all, but I don't have time to do that today. I need them in a PDF format. Does your city have the ability to scan them in and send them as PDFs? Probably. I don't know of too many. I actually do know of some that don't, very, very small towns, but good chance that your city has the ability to do that with existing software. So you don't get to come back and say, no, I'm not doing that. You can have them in paper or not at all. That's not going to fly. Scan them in, send them the PDF, right? If they want it on a thumb drive, put it on a thumb drive. You can charge them for the thumb drive. Can't really charge them for your time most of the time, but if they bring their own thumb drive, plug it in, give it to them. You don't charge for that thumb drive, right? If you have the ability to convert it into a medium or in any another format that they want, as with your existing software, you have to do it, right? You do not have to go out and buy brand new software, though. You do not have to go buy brand new software or spend a bunch of money just to convert one thing for one person. If you don't have it with your existing software, then you don't have to do it. You can tell them what you can give them, talk to them, open that line of communication, see what maybe they have an old computer and I don't know, they don't have Microsoft Word, but they need some type of other doc, free read or something. You don't have that. You don't have to do it, but talk to them, find out what's the best way for them to get it, find a compromise. Definitions are important. We've already kind of talked about this, but medium is just the physical form of the material on which the record's information can be stored, right? It's functional. Format is the organization and arrangement. So digital would be your medium, format would be PDF. Does that make sense? Okay. Physical would be your piece of paper. Format would be justified, something along those lines. So I got ahead of myself. Let's jump back. Kind of a bonus question here. Does the FOI, do requests have to be made in writing? If you're real quick, you saw the answer, but does a FOIA request have to be made in writing? No, right? A lot of our cities and towns do have a policy that they want FOIA requests to be reduced in writing. That is very helpful, right? That way you can say, hey, you've got a FOIA request, cool. Fill out this form for me. Put your phone number and email address down. Let me know who you are. Provide some, proof that you're an Arkansas citizen, and then tell me what you want, right? And we'll have that. And that way I don't have to rely on my memory. I drink a lot of coffee, but I can't remember everything. I know you all talk to a lot of people all day. If you talk to somebody at 8 a.m. and they just tell you, hey, when you get back to the office, send me the last 3 emails you sent. You don't get back to the office at 7 o'clock at night. Are you going to remember that conversation? Probably not, right? It helps to have it in writing, but it does not have to be, right? FOIA requests can be made verbally. They can be made in writing. They can be made over the phone. You can send a fax, Morse code, send up smoke signals. You can interpret it. They can send a request that way. But it is really helpful to go ahead and have it put in writing. So just remember that if somebody does verbally make a FOIA request, that is a valid FOIA request, and you do have to comply with it. There's also no magic words, right? Take that out of your mind. It is not, FOIA requests are not limited to, what's your name, Emma? Miss Robin? And this is not real, so don't do it. Miss Robin, I want to see the email that you sent at 12:15 on Tuesday. I didn't say FOIA. I didn't say pursuant to Arkansas Code 2519-105. I just said I want to see that. That's a FOIA request. Treat it like a FOIA request, right? If they want to see a public record, no matter how they verbalize that or tell you about that, they are an Arkansas citizen asking to see something that's probably a public record. Fire up those neurons and say, hey, we're going to treat this like a FOI request. It seems a little like, why would we do that? Because, again, I think a lot of times we think of FOIA as being, I got a FOIA request. I got to go fill this out. Start treating everything like a FOIA request. It becomes repetitive, right? They want public records, so we're going to act like it is. Yes, ma'am.
So it does for requests. It can just be a time.
Yeah.
You could have said
It has to be. The request has to be sufficiently specific to let the custodian know what they're going to go find, what they're going to go look for.
random time.
That they may be, very well may be, and I say that in the sense of maybe we think something happened, right? We know there is something going on that happened between the hours of 12 o'clock and 1 o'clock, right? So I think, and we don't know exactly what it was, but I think something went down and some emails were sent, some communication was sent from this, but I don't know what it was about, but it seems shady, all right? So I need those records in that time frame. That would, as long as you know who you're asking it of and who you're addressing it to, I think a court would say, hey, they asked for the records, the emails that were sent from 12 to 12:05, 12 to 12:15. That's sufficiently specific to tell you what to look for. And we'll talk about this kind of jumping ahead a little bit, but if somebody asks you for something and they're like, I want to see all public records that Carol has sent. Carol might have been working at the city for 20 years, that doesn't tell you the broad scope of what they're looking. That's broad, right? That can be 20 years worth of everything. I mean, that's going to kill like 15,000 trees. Call them, talk to them, be like, hey, Carol is wordy. Carol sends a lot of emails. What are you looking for? Like, let me know. I can help you find it. Narrow it down. It'll save me time. It'll save you time. I'm not going to drop a dump truck of records on your front porch that you have to go through. Help me help you, right? So narrow that scope a little bit. Again, communication, right? So response times. How long does a public employee, a public official, somebody who's paid by the government, how long do they have to turn over these records? I've got you holding up 3. What do you mean by that? Okay. So got somebody say 3 days. Anybody else got a better idea or a different idea? It depends. Also, yeah, ultimately that's the right answer. So as a general rule, we need to turn over public records immediately. If you have them, you have access to them, they're not being used, they're not in storage. Somebody walks in, says, I want these minutes from the last 2 council meetings, and they just happen to be right there. You've got them. You say, okay, yeah, sure. Let me go get that made. The law says that we have to get that done immediately, right? It doesn't give us a specific time frame, but it says immediately. Again, with reason, right? So we'll get to that here in a minute. But the second part of this, if a record is considered to be in active use or storage, right, then the 3-day rule is a little bit of a misconception, right? It's a real thing, but it's a little bit of a misconception. So if it's an active use and storage, the public entity, the employee, the custodian, has to set up a time within 3 working days that the individual can come get their records or review them, right? It's not that you have 3 days to necessarily do it, although you can, but you have to set up a time and date within 3 working days for them to come get their records. That's in 2519-105E. That's where that 3-day rule comes from. But if your record, again, if it's just right there, you've got access to it, you can get it. It's not an active use. You guys aren't using it for some type of open case. It's not being reviewed by the city for some type of planning purpose, right? Then we need to get it over right now. Go ahead and mark that off your to-do list, right? Get it off your plate. You don't need that hanging over your head. Go ahead and do it. If it is an active use or storage, you have to set up a time and date within 3 days for them to come in and review or get their copies. Now, in saying that, is it that simple? Does anybody in this room think it's that simple? That is a very short time span. How many of you have gotten FOI requests that were for 5 pages? A lot of us, right? How many of you have gotten FOI requests that would fill up 5 boxes? A lot of us. I've had that happen. So is it functional? Is it within the realm of the human ability to go through 50,000 records in 5 days? Maybe if you've got an army of people in this room, right? Maybe if we all get together and we're like, hey, let's go through these and we can do it in 3 days. But I doubt that most cities, what is there, about 30 to 40 folks in here? I doubt most cities have the ability, the capacity, or the budget to sick 40 very intelligent individuals on City Hall to go through records within 3 days. That's when it becomes difficult, and we need to make sure your city attorney is notified. There is an AG opinion out there. Again, AG opinions are not law, but they are very persuasive. And it was actually, the question was asked by Mark Stodola. Mark Stodola is a friend of mine. He's the former mayor of Little Rock. He now contracts as a field rep for Central Arkansas. I'm not sure he's over you guys or not, but he does a lot of contract work for us. But when he was mayor of Little Rock, they had this issue. Somebody basically requested about 14 years worth of records that were going to be to the tune of about 100,000 copies of paper and stuff that they had to go through. And they said, AG, do we have to turn this over in 3 days or we're going to catch a lawsuit? We don't have the ability to do that. What the AG said is that start complying, right? You do have to have a reasonable amount of time to fill the request, though. Again, not binding, but I have seen courts look at this and go, yeah, that makes sense. You can't get 50,000 pages read, redacted, reviewed by an attorney, and then turned over or digitized or things. That's not functionally possible, right? That bends the realm of physics. We don't have that ability, right? And so what the AG said is you have to have a reasonable amount of time to fulfill the request. You have to have a reasonable amount of time to have it looked at by your attorney, right? To make sure that things that are redacted, to make sure that this doesn't have ACIC reports in it. Those aren't public records. right? Those don't go out to anybody. That it doesn't have somebody's social security number on there that somebody's going to go steal their identity, right? You have to have those reviewed. You have to go through the redaction process and things like that. So you've got to have a reasonable amount of time. Now, in saying that, you are not going to do yourself any favors if somebody comes in, wants a bunch of records that's going to fill up boxes, and you know that, man, Caleb told us at that meeting that we have to have a reasonable amount of time. I'm going to drink my coffee, smoke my cigarette for 3 days, and we'll get to it when we get to it. A judge is going to look to see if you started complying, right? You need to call them, set up a time and date, time and hour within 3 working days for them to come pick up something. Start complying, right? Start going through the records that you can, do the redactions, put them in a nice little stack, put them on the thumb drive, send them via email, start complying. And that way, if you get drug into court for this, you say, look, judge, we are actively working. We have got a staff working on this. They are busy at the moment. We are going through records right now. Here are 300 pages that we've already turned over to him, that to the requester, that he has or has not read, that they are available to him. We've turned it over. We are actively complying with this, but we have to have time to review it. We don't want somebody's personal, private, constitutionally protected information getting out. We don't want important documents that are police documents getting out. We don't want documents that are part of an open active investigation. We don't want documents that show who our informants are. We don't want documents that show who our undercover cops are. We don't want this guy's FOIA request, this person's FOIA request, to get somebody killed, because it is that serious. It is a life and death situation. And you do have to go through that material meticulously. And as long as you are starting to comply, you are engaging in substantial compliance, the court is likely to go, you know what, you're doing your jobs, and we're going to give you more time. Continue to do what you do, fulfill your obligations under the FOIA, but make sure you're turning over stuff regularly. Show a pattern of compliance so that you stay in the good graces of the FOIA and the court. We mentioned a while ago that records do have to be sufficiently specific. Again, it does not do me any good to come to you and say, I want, you remember that thing that's from that one time? I want those. What am I talking about? Does anybody? I don't know. Right? That's not sufficiently specific. How many folks in this room have gotten FOIA requests that you look at, you kind of go cross-eyed for a second. You're like, what? Like, what is this even? Is it like written in wingdings? Like, I don't understand this. What are you looking for? You have to be able to know what you're looking for. Call them, text them, reach out to them. That's also why it's really good to figure out who they are and how you can contact them. Just reach out to them and say, hey, would love to fill your FOIA request. That's maybe that's your job. Maybe that's your whole reason for your job, is that it's filling FOIA requests, right? I want to help you. I don't know what you're looking for. Talk to me. Like, what are you actually searching out, right? Somebody wants to see all the bank records for the last 10 years. That's a lot of records, right? Well, what are you looking for? Well, I actually think that somebody maybe misused some funds and that they were going through and buying personal stuff at Home Depot. Okay, well, I can actually pull you, we have a report. We can show you when Home Depot purchases were made. Can I just give you that? Sure, that's going to be a lot less paper, and it's a lot less time for me as the requester to go through. By the way, that's a neat little trick. The people who are requesting a lot of records, if they're doing it in good faith, they've got to go through everything that you give them too, right? And so it's also going to take them a lot of time. They also, for the most part, don't want to go through hundreds of thousands of records that they don't need. They want to get what they need. So talk to them, help them narrow the scope of the request, make it more sufficient, more specific, so that you can go get what you can get in a very short amount of time and give it to them and go ahead and get them to work, and you can move on to the next task. But importantly, regardless of whatever is asked of you and whatever the answer is, you are almost always, I do not know of a situation where you do not have to respond in writing. You are always going to have to respond in writing. Have a look at 2519-105A3 when you get a chance. If no record exists, type it out, write it. Hey, sorry, we don't have any records that are respondent to your request. Is there something else that you were looking for, right? Maybe narrow the scope again. This is not anything that we have. If a record does exist, but it's either wholly or partially exempt from disclosure under the FOIA, the custodian has to basically write down and specify the actual exemption, right? I should have brought a piece of paper. Let's pretend I've got my email, and on this email there are 3 paragraphs, and this paragraph is all about a confidential informant. Do I get to say, nope, this whole thing we're hiding it under here? No, right? The law says that you do still have to turn over a record, even if it's got confidential material in it,
you redact that material and anything that could be that could lead somebody to know what that stuff is, right? Black it out. You got Adobe, use Adobe to redact it, go through that, and then you turn it over. Again, exceptions to that, but for the most part, that's the way it works, right? We talked about bank statements a while ago. Do you want every citizen in Arkansas to know what your bank account is for the city of Hot Springs or what the routing number is? No, because they can steal your money, right? We have an obligation, public trust, right? A duty to be good stewards of the public trust, of public funds. We've got an obligation to make sure that those tax money, that tax dollars, those things in our bank accounts, that they're only used for public purposes and that they're safeguarded. So we redact that information. We redact our account numbers and things like that. But when you do that over here on the little sidelines, or maybe if you're typing on a computer, you leave a comment, redacted according to 2519-1. If let's say that this is a personnel record that with the social security number 2519-105B13, right? That's the exemption for that. Just put it on there, let them know what they're citing to. Are they going to know that that's got some type of private personnel information? Sure, but they're not going to know what it is, right? And so you write that down, but you provide it in writing. If the city, how many of you all get requests for records that are from the sheriff's office, right, or from the county government? I get this a lot. Hey, I've got this person asking us for minutes from the last quorum court meeting. We're a town, right? We're a city. We don't have that. I can get it. I'm Sharon up at the county will give it to me, but isn't that Sharon's job? That is Sharon's job. So what you do is you respond in writing. Say, dear requester, appreciate your request. Unfortunately, we do not have any respondent records as we are not the custodian of the county's records. The county is the custodian of the county's records. I've done you a solid. Here is the county's number and the county's email address. Go ask them. God bless. So if there's anything from the city, come to me. But if we're not the custodian and we know who the custodian is, we provide that in writing. Don't let that part trip you up. We're defense lawyers at the end of the day. Even though I don't litigate, most of my job is risk management. And at the end of the day, I'm cynical. Like I'm Team Asteroid at some point. Like I'm just a cynic at heart. I try not to look at everything and assume everybody's wanting bad faith or something like that. Sometimes as a lawyer, I have to be. There are some attorneys in this world who use the FOIA with the sole purpose of seeing if they can trip somebody up so they can file a lawsuit, so they can get attorney's fees, they can pay their bills. I don't like that. I don't think that's what the FOIA was for, but it allows for that. It's a thing that happens. And we know that some people do use it for that. If you don't provide the answer in writing, they might sue you for that. Now, what is a court going to do? The court's going to go, okay, well, the law says you had to provide, something in writing and respond in writing, and you didn't. So the court's going to order you to start responding in writing. Okay, that's slap on the hand. That's not bad. Also, we're giving that guy $1,300 of public funds for his time and energy and efforts. Ching, yay. Let me go do the same thing, right? A little bit of a cynical view on things, but that's part of my job as a defense attorney, right? Don't let this trip you up. Don't let this be the reason that you have to pay somebody's lawyer fees. Speaking of money, I know you already see the answer up here. The answer is maybe, but can the city charge? Can you charge at all? If you get a FOIA request and it's going to take a lot of time, it's going to take a lot of materials, they want it on paper that you have to provide, can you charge for that as an expense? I know the answer is maybe. And that's the best answer we can get. The real answer is that a public entity can charge, right? For the most part, you can only charge for actual cost of reproduction. If somebody comes in and they say, hey, I want all of these records, and it's going to take 3 reams of paper, a box of paper comes with 6 reams, you know that box of paper costs $40. I don't know if that's actually what it cost or not. And we know that it used half of the paper in that box. You can charge them $20, right? If they come in, they say, well, I want everything, but I don't want it on paper. I want it on a thumb drive. Are you going to provide you ask the requester, are you providing thumb drive? No, I don't feel like going to the store. Just give me a thumb drive. You can charge them for the cost of that thumb drive. You have to provide an itemized receipt, right? But you can charge for that. Think about it this way, though. Most FOIA, with the vast majority of FOIA requests, couple emails, couple pieces of paper, is it going to be worth your time to charge? How much do y'all think a piece of paper costs? Not a lot. All right. Now, if you just a single piece of paper, Doesn't cost a lot. We actually did the math one time, and we factored in the cost of the paper, a single piece of paper, the toner, and I think a rubber band for something. And it basically boiled down to being about 0.002 cents a page, way less than a penny. So it would take a lot for the actual cost to build up to even make it worth your while to charge for that. Now, again, if these are voluminous requests and you know that it's going to cost a lot of money, sure, charge them for the actual cost. And if you have predicted that it's going to cost at least $25 or more, you can ask for that money up front. My God, you're requesting 4,000 pieces of paper and you want them in hard copy. That's a lot of paper, a lot of money. It's going to cost us about $60. So we'll get it to you, but you need to bring $60 to us right now. It's more than 25. The law says we can get that up front. That might deter them from asking for really voluminous. That might be the thing that inspires them to go, hey, actually, you know what? I just wanted this very particular couple of emails. I actually know what I'm looking for. Let me narrow it down for you. I'll take my 3 pieces of paper. I won't bring you money. We're all going to go to bed happy tonight. But the one thing that you can't charge for on a general matter, there's a separate law that actually applies to police departments. I want to talk about that in a second. Generally speaking, though, you are not allowed to charge for personnel time, right? I wish you could. Other states, their FOI laws allow for the charge of personnel time, right? Because it takes up a lot of public funds for you to stop the other work that you're doing, the other important work that you're doing, and go find records. Our law does not allow you to do that, though. The legislature has said, look, providing for public transparency is every city employee, every public employee's job. So getting those records is your job. You're not getting paid extra. The city shouldn't be paid extra for you doing your job. That's the way that they think about it, right? So I think reasonable minds can disagree to that, right? I think those are reasonable arguments on both sides. I see the point. I just happen to be on team municipalities, so I wish we could charge for that. But we can't. The law does not allow for that. However, and one thing to remember too, though, it doesn't define actual cost in the law. It does indicate the actual cost. It will include the cost of the medium of reproduction, supplies, equipment, maintenance. It's usually a very low amount. And the city can also charge if you have to mail it. Maybe they're Northwest Arkansas, they want it sent by certified mail. That's an actual cost you can charge for that. So there's 2 statutes that we have to talk about, though, if we're talking about charging, right? Number one, it's very important to remember does the FOIA Act require you guys to create a document? No, it doesn't, right? So me and Mr. Albright, we had a conversation on Tuesday. Somebody saw us talking on the street and they say, hey, I want all the records of that conversation that you guys had. Well, you didn't have your body cam on. I didn't write it down. Nobody transcribed it for us. There are no records. No, I want to know what that conversation about. You have to go transcribe that for me. No, you do not. You absolutely do not. You do not have to create a record. The FOIA applies to records that are in existence at the time the request is made. However, it might be easier for some requests if you go, okay, you're wanting 40 different things and there's about 100 emails for each one of them. I can reduce this very quickly to a spreadsheet and give that to you, right? That might be a reason to create a record, save you some time, save them some time, everybody goes to bed happy. 109 does not really apply to that, right? So what 109 applies to is when the city agrees to create a record that is not in existence that compiles or tailors electronic data, metadata, right? I want to see the metadata from every city's cell phone that any city employee has, right? I want to know how much time you're using, et cetera, et cetera. There's probably not a record that has that information. I want to know what cell towers are pinging on and all this stuff, right? Like that. There's probably not a record in existence that has that. You are not obligated to make it, right? But maybe you're like, okay, this could be used for good reasons, or we want to do this. And so we're going to choose to, and we're going to take that metadata and we're going to compile it. We're going to tailor it. We're going to break it down and we're going to make it useful. In that case, the law says that you can do that and you're allowed to charge for actual costs of anything that they have, but you're also allowed to charge for some time, right? You're allowed to charge for time if making that document, compiling that metadata takes more than 2 hours of public services, public workers' time, then you can charge for it. the requester may be charged for personnel time not to exceed the salary of the lowest paid employee with the skills to create the record. Does that make sense? In a nutshell, I hope it does. I look at this stuff every day. Like at some point you go so far into the weeds that simple things don't make sense anymore. That's kind of where I'm at with this. But in a nutshell, basically that's what it's saying. If we are asked to compile metadata and things like that to create a record, and it takes us 3 hours or more, then yes, we can charge for that personnel time, right? It's going to take IT a while to do that. Very, very intricate computer skills, things that I don't have. I'm a Luddite. I'm a terrible millennial. So I don't have those abilities. But you can only charge for the lowest salary of a person with the skills to do that. The other one applies to most folks on this side of the room, right? 2519-112. This only applies to requests to government, to law enforcement agencies, right? For visual, audio, or audio-visual media. Body cams, dash cam footage, right? Y'all get requests for body cam footage pretty often, right? I imagine you do. So again, we said that the general rule is that you can't charge for time. If somebody's saying, hey, I want the body cam footage from X day from X officer, or from any of the SWAT team members, that's actually a really good way to think about this. I want every SWAT team member's body cam footage from this day. It's not an open investigation, right? There's no other exceptions that would kick it out. So are those public records? Yeah, they fit within that, right? We would redact anything that needs to be redacted, but we have to turn that over. But when that request is made, 112 kicks in. And what 112 does is say that when the law enforcement agency can charge for the personnel time spent retrieving, reviewing, redacting, and copying any audio, visual, or audio-visual media, if and only if, it takes more than 3 hours of the employee's time to do that, right? So if this took you 2 hours, 2 hours and 50 minutes, 2 hours and 59 minutes, sorry, you don't get to charge for that. 3 hours, and you do get to charge for that. What do you get to charge? This is a tricky part, right? I actually, once this clicked for me, this was kind of the way that we were looking at this and confusing everybody. Clicked for me not too long ago. So let's say, Sergeant, let's say it takes you 6 hours. You're the person who's doing this, and it takes you 6 hours. Are they allowed to charge, and don't tell me what you make, but are they allowed to charge for 6 hours of your salary? No. What you are allowed to charge for is this bottom thing. It has to be prorated for each hour of running time of the audio, visual, or audio-visual media provided to the requester. So $20 an hour is what you charge, not to exceed $20 an hour, per hour of runtime of the document that you turn over. That is very confusing, but that's the way that the law reads. So it takes me, today I'm a cop. I borrow a gun or something. Takes me a cop 6 hours to redact my body cam footage, and I'm going to charge for this. How much body cam footage did I just turn over? 4 hours worth. I can charge $20 an hour for the 4 hours of runtime. Doesn't matter that it took me 6 hours to do it. I can only charge for the prorated amount of the runtime. Maybe it took me 3.5 hours for this for a 30-minute video. I don't know. It shouldn't, but maybe it did. I don't get to charge for 3.5 hours of my salary. I can charge for a prorated amount, not to exceed $20 an hour, for 30 minutes of runtime. About $10, $10.50, right? It matters how much runtime that video is. So if you're operating under this, you have to realize what you can charge for. Don't get caught up in the trap. And I talk to a lot of police chiefs and a lot of officers. I'm Gary Sipes, who's he's the president of the Arkansas Chiefs of Police Association. He and I talk. He works on the floor above me, and we talk about these things all the time. And I actually go give this conversation to like the police chiefs and things like that. I've talked to some departments that are charging for the salaries of the officers and how much time they took to do the redaction, and that's not what we do, right? That's not what we do at all. We should be making sure that we're complying with the law. So let's remember that. So again, I mentioned earlier, right? We've got to redact things, right? Redaction is key. We look at the law, 2519-105, Section F. It says no request to inspect, copy, or obtain copies of public records shall be denied on the grounds that information is exempt from disclosure that's commingled with non-exempt information. Have the paper, you find the exempt stuff, you redact it, you give it out. Not too difficult. Any reasonably segregable portion of a record shall be provided after the deletion of the exempt information. They still get the stuff that's not exempt. If the amount of the information that's deleted has to be indicated on the record. or in a portion of it. Just basically say, hey, this is what we redacted. Here is the law that says that we can redact this, right? This is why this was redacted. And we'll talk about some of those exemptions. And if it's necessary to separate exempt from non-exempt information in order to permit a citizen to get that record, the custodian shall bear the costs of separation. I've had a lot of cities go, okay, they want to review public records. They want physical copies of this, right? Bank records. I like using that example. They want physical copies of bank records. Well, I can't just turn over the bank records to them, and I can't just run the bank records through a copy machine, because then what do? They've got access to our bank account information, right? They may go out there and they may steal all our money. We don't have no pothole money, right? I like my potholes to be filled. We don't have money because somebody came and they hacked our account, they got our information, they ran off with all our money. Cops are looking for them. What you have to do in that case is they want a physical copy, so you take the original, right? And maybe you have it in Adobe, you scan it in and you redact it, right? But maybe you don't have Adobe, right? Maybe you don't have a software that allows you to do that. Maybe you have to take your original copy, make a copy of it, take the copy, take one of those redacting markers and black out all information, and then take another copy so they can't hold it up to a light and read through it. Well, that just took 4 pieces of paper to make one copy. But that's a cost of separation, right? You don't get to charge for all 4 of those pieces of paper. You get charged for the piece of paper you gave them. Does that make sense? It's difficult. It's kind of hard to swallow because, again, that paper was paid for through tax money and you had to do what you had to do, but you don't get to charge for all the pieces of paper, the cost of separation. You don't get to charge for the pen that you used. You don't get to charge them for, maybe you did it in Adobe and you've had Adobe for a long time. You don't get to break down, hey, Adobe cost us this amount of money this month and we're going to charge you for part of that. You don't get to do that, all right? You don't get to charge for the cost of that separation. So here's kind of one of the functional parts is we have to determine at every time if the record is releasable. A record is going to be generally and probably releasable, but there's several exceptions. We find those in 2519-105B. Records with exempt information, like we said, they're still public records. The custodian is still responsible for responding in writing as required by law. We segregate the parts of the record that are exempt, and then we turn the other parts over. It's also, and we'll talk about some of these, it's important to know that the law in different parts say that certain things are not public record. Just because it was made by a public agency, it's stored in a public building and stuff like that. Remember that rebuttable presumption? The law says that certain things are not public records, and for very important reasons. And I take this very, very seriously. So we're going to look at those stuff. 2519-105B has about 28 exemptions, although I think they've gotten rid of one of them, so there's only 7 that function in that part. And I work for municipalities, right? I don't work for the state. Most of the way I think about things comes from local government, stuff like that. So undisclosed investigation by law enforcement. You guys have an open case. I don't get to ask you for what evidence you have on me. This is an open investigation. We don't turn those over. Documents that the judge has said we don't turn over, right? Documents that would give an unfair advantage to competitors. How many of you who deal with, with contracts where you have to go through bidding, how many of you have had somebody before those bids are open come back and say, hey, I want to see all the bids the day before they're due? Well, they're sealed, so you can't give that over, right? That'd get an unfair advantage. Identities of undercover law enforcement officers. We don't turn that over. And we'll talk about this in a minute. Importantly, we don't turn over information of non-undercover officers that can be used to compare lists and find out who is undercover. There's a case out of Little Rock. Anybody here familiar with Russ Raycop? Heard that name before? I think some folks probably have. Mr. Raycop FOIA'd a bunch of stuff. He wanted to see the employee list for everybody employed for the Little Rock Police Department. Or no, this was actually the state police. And then he said, I want to see all of their, how they take those nice pictures where they look sharp in their hats and their uniforms. I want to see all the pictures. I want all of those. And they stopped for a second and said, wait a second. We just gave you an employee list, and now you're wanting to see all the stuff of everybody who's not undercover. 2 + 2 is 4. You're trying to find out who our UC officers are so you can out them. No, that would put their lives in jeopardy. That'd put their families in jeopardy. We don't do that, right? We'll talk about that here in a minute. Personnel records. We're all public employees. We all have a personnel record. Those are generally releasable, but they are exempt to the extent that the disclosing that information would kind of create a clearly unwarranted invasion of personal privacy. Personal contact info of non-elected public employees. We look at vulnerability assessments of public water systems. Our public water systems are considered to be critical infrastructure. Terrorist organizations and foreign countries desperately try to break into our public water systems. They do it all the time. How many of you remember the big pipeline shut down about 3 years ago in Florida? Russian hackers were able to get into a major water supply pipeline, one of the big pipes, and completely shut down water to a big portion of Florida. And they held it, they did it through ransomware, and they basically held it hostage. Now, that may seem to a lot of us to be inconvenient, right? That's annoying. It's not annoying. People died. Hospitals didn't have clean water. Elderly people didn't have water, right? There's a big body of water right next to Florida, but you can't drink it. It is critical infrastructure, right? We have to protect those. So those plans and documents and things like that are not open to disclosure. Vulnerability assessments of public utilities, same thing. Personal information of former water system customers. We do not give that out, right? We do not, like, you can ask me how much did your water system make this year? That is releasable information. How much water did Caleb and his family use at his home address? That's on a public record somewhere. They've got papers that say that. It is not releasable. We redact that information. They don't get to know my address and things like that. As a citizen, they don't need that information. A&P taxes that cities collect, we don't turn that over. And confidential informants, non-police officers, but the folks that you guys work with to help catch the bad guys. We don't out them either. If we have documents that say who they are, we do not turn those over. Again, not all exemptions are listed in the FOIA, right? There's a big body of law. The Child Maltreatment Act, for y'all's purposes, is probably one of the most important things about this, right? We do not turn over any documentation, records, reports, or any data that has been created, collected, or compiled by the Department of Human Services, the Division of Arkansas State Police, or any other entity authorized under this chapter to investigate or provide services to children, individuals, or families. We don't give that information over. If there has been a sexual assault, a sex crime, we do not turn over that information, and we'll talk more about that. There are some limitations to that, but we don't turn that over. If the record could still lead, even if you were to redact that information, right? Maybe, again, very serious, and I even hate talking about this. I hate that it exists in the world. If you get a request for some records or something that can deal with a child molestation case, and it's got adults and stuff in there, people who aren't, that no FINS request was called or no child maltreatment. I mean, that's just the adult, whoever perpetrated it or a family member of them. But we redact out the kid's name. Is that good enough? No, because they can still use the information in that record to find out who that kid was. Very big, kind of very well-known case out of this. Any of y'all ever heard of the Duggars? What was it, 19 and counting or something like that? One of the Duggar children, an adult child, he was accused of, and I think at some point convicted of something related to child molestation. And Entertainment Weekly, I think is who it was, but one of these national tabloids, they FOIA'd, I think it was Springdale, and they wanted these records. They wanted this information. Actually, believe it or not, I think Oprah had something to do with this. I'm not kidding. Because they were trying, this is big news, right? The Duggars are public people. And the city said, well, we have this record and it's got the kid's name, so we can't turn that over. We'll just redact it, right? But guess whose names they didn't redact? Somebody close to the family. Something that was used to say, okay, this is the family, and these are the specific girls that they are talking about, the siblings, right? These are the 4 girls that he is alleged to have abused. And they took that power of deduction, 2 + 2 = 4. Well, 4 - 2 is still 2, right? So they found out who those kids were, and the next thing we know, Entertainment Weekly, all these tabloids are dragging these people's lives, a very important part of their life, something that is very private, very traumatic, and now all of a sudden it's blasted over national news, right? And they didn't want it to be kept secret, so that's why we don't turn those things over. And importantly, with child maltreatment stuff, right? Again, DHS stuff. If there was a call into the FINS hotline or the child maltreatment hotline, stuff like that, it exempts the entire document. We do not turn any of that over. If a child is involved, always get with your city attorney. Always have them or go through the process of looking up, make phone calls to find out if there's been a call into the child maltreatment hotline, if there was a FINS case or something like that, right? That way we know for sure, and we can say, we are not giving you this document because of this, right? So do not turn that information over. There's a lot of information that seems releasable, right? But it's exempt. the records are exempt if the disclosure, specifically like photographs, would reveal the identities of law enforcement. We kind of talked about this. I'm not going to go over it anymore. The Arkansas State Police v. Raycop case out of 2022 is a pretty interesting case. If you get a chance, you want some fun weekend reading, and you're a nerd like me that reads court cases on the weekends, go check it out. It's interesting because it shows you the tricks that this individual used because he wanted to know who the state police's undercover officers were. And he did it through separate FOIAs, and a savvy person at state police caught it, realized what they were doing, and they said no, right? And so that way the state police's undercover officers did not get outed and get their lives put in jeopardy or their families' lives put in jeopardy. Right? This is very important. A lot of times we think of FOIA as just a part of our jobs, right? As turning over emails and things like that. The FOIA could get somebody killed if you do not understand it. That's not fair to say. A misunderstanding or ignorance of the FOIA could get somebody killed. The FOIA protects this stuff, right? So that's why it's important for us to know it. Redacted police reports, court orders, or other documents involving victims of a sex offense, not turned over, right? That stuff is exempt. It should not be released by law enforcement agencies, except to the extent that disclosure is only of the site of the sexual offense, if it's required by law, necessary for law enforcement purposes, or if it's permitted by the court for good cause. That's that Dillard v. Springdale case. That's the Duggar case we were talking about, right? It's Dillard because that was one of the victims' names. Now they got married, but that's that case. Go check out that. Also, there's additional support for non-disclosure found in the Child Maltreatment Act that goes into more detail. I could give you an 8-hour course on that. We don't have time. Again, y'all have guns and lunch coming up. I'm not getting in the middle of that. So ACIC reports, also not releasable, right? The law says that criminal history information collected and maintained by ACIC is not considered public information. It's not that it's not releasable, or it's not that it's a public record that we have to redact. It's not public information. The FOIA doesn't cover it at all, stuff in ACIC reports. So we don't turn those over. The AG has said that these documents should be redacted prior to the release of the documents, but before it ever gets out of your hands, right? Like it should never come to you or get out of your hands at all, but we just don't turn that over. So I like these hypos, kind of cover stuff, get us an understanding, make sure we're practicing what we preach a little bit. But police scene photographs and pathologist photographs, and the investigation has been completed. Is that releasable? Well, we'll start with mostly non-law enforcement. Who over here thinks that this stuff would be released? Got a couple? What about you guys? This stuff releasable? You guys and girls?
Give me a second. They did.
No, it's just the scene photographs. All right. Okay. So maybe. Trick question. So there could be constitutional privacy rights, right? Constitutional privacy rights can supersede the statute. Constitution's federal, right? So federal law, we know that federal law tends to cover up everything underneath it. It's the supremacy clause. And they look at situations where, as an individual, your stuff might be otherwise releasable, except to the extent that it is very, very personal, and the Constitution gives us constitutional privacy rights. And so there's a way that we have to look at that. Again, your city attorney needs to be one helping you make these decisions, so get with them. But the court looks at these kind of personal matters, and they say that personal matters it's information that, number one, the individual wants to and has kept private or confidential, that except for the challenged government action can be kept private or confidential, and that to be releasable, the person, it would be harmful or embarrassing that if it was disclosed. There's a case called McCambridge v. City of Little Rock that looks at this. And to really understand when this gets to court, what the judges will do, they use this balancing test, right? So they look at it and they say, does the individual's interest in non-disclosure on one hand, and they put the public interest, right, the government's interest in disclosure on the other, and they weigh them. And keep in mind that the FOIA always leans towards disclosure. The default is disclosure. We have to have a very on-point reason not to turn over public records, right? So we have to balance those things. So that's the test they're going to use. This last thing, though, is really important. The privacy right must be asserted by a living individual whose own privacy would be invaded. City of McCambridge v. City of Little Rock was a court case to where an individual was shot and killed, right? And an autopsy was done. And this individual, this corpse, this naked body, there were autopsy photos made, right? And somebody FOIA'd the photos. The deceased's mother came out and said, no, I don't want my son's naked corpse blasted everywhere. Is that understandable? Yeah. Well, I think any of us with kids or nieces and nephews or family members, we would want that. We would understand that. But what the court said in that case is, ma'am, we understand your point. These are public records. It's not a sex crime. There's no other thing that we can cite to prevent release. And the law says that the privacy right has to be made by a living person. It has to be their own privacy right. As a mother, your privacy rights are yours, but you can't evoke your child's privacy rights after they're deceased in this particular case, right? So those photographs were releasable, and they were released. That's a hard thing to live with, right? But that's the way that the law shook out, because the FOIA leads towards disclosure. It bends that way most of the time. And this was not a constitutional privacy right of an individual who was alive. So other things, and we see this a lot too, you guys have a full-time attorney on staff, but a lot of cities use contract attorneys, or you use the municipal league. Have any of you ever been involved in a court case where maybe you were sued civilly and the municipal league stepped in to help? Hopefully you guys had a good experience with that. But we don't work for the city of Hot Springs, but we are public and we're subject to FOIA too. But let's pretend like I've got a private practice, right? I'm dealing with divorces and stuff like that, but I also maybe represent Hot Springs Village, so maybe I'm their city attorney, but I'm otherwise in private practice, and I'm defending them in a case, and I've got some of those public records, right? And they get FOIA'd for it, and Hot Springs Village clerk says, well, we don't have those records. They exist. We're the custodian of them, but they're at Caleb's house. And so we're not giving them over to you. That's not going to fly. Not going to fly at all. You're still a custodian. What you got to do is you got to call me and say, hey, we've got a request for these records. Can you go ahead and make copies of them, redact them, get it back to us so we can turn them over? If they're in the hands of a contract attorney, doesn't exempt you from disclosure under FOIA. Same thing is true if we send records to leg audit, right? Number one, always have a record. If you're sending your records to leg audit to be reviewed, either keep the original copy, or if they're demanding the original copy, make sure that you have a copy on hand, because it's going to be very inconvenient when you have to drive to Little Rock to go get with a pickup truck to put a bunch of files in the back of your vehicle and drive them back, because you've got to turn them over. Just because they're not in your possession does not mean that you're not a custodian. Does that y'all understand that? Like, does that make sense? I talk to people sometime, and just the sheer volume of stuff I throw at them, it makes it hard to kind of understand. The best example I can use is child custody, right? We have two different concepts in the law of custody when it comes to kids, right? Physical custody and legal custody. Those are two different things. A person may have legal custody of their child, right? They get to make those important decisions. Where do you get your doctor at? These kind of life decisions, things like that. But they may only have partial custody, maybe half custody, or maybe no custody, no physical custody at all. Maybe the kid lives with a different parent and they just get weekends or things like that. But you still have legal custody, right? Records are the same thing. You may not have physical custody of that record, but you still got legal custody over it, right? So you're still entitled. You still are obligated to make sure that the public has access to information that they should have access to. Other things that seem exempt, but they're not, right? We talk about a lot of things with the police department, but jail logs, arrest records, shift sheets of officers, again, not undercover or things like that. Vehicle accident reports. You have to redact minors' names and addresses unless it's asked for by a parent or an attorney, or ACIC, which is not releasable and should be separate. But those things are releasable. Again, you're like, okay, well, this police department stuff, jail records, things like that, maybe it seems like maybe it shouldn't be. The law is not on our side on that one. They are releasable. You may have to redact some stuff, but we turn those over. Attorney General Opinion 93-106 kind of talks about this from the sheriff's department perspective, and they look at those jail records. Again, records that are in the possession of a retained attorney. And then we'll talk about this other one. I want to put a pause on the employee evaluation job performance records. That's a whole separate section of the law. And then some redacted, important to remember, not mostly for y'all, but for attorneys. Attorneys may have stuff that they've gotten through discovery, right, that was redacted for discovery purposes. Discovery from the legal sense is different from discovery from the FOIA perspective. And so you may have documents that you have that have redacted information from a discovery, from a lawsuit, but that material, the redacted portions, may not be redactable under the FOI. So you have to unredact that information. There's not a exemption that it would apply to. So we have to make sure we look at that. So you have to look at these kind of court documents or lawsuit documents to find out, is there information that should be redacted or that should be unredacted for the FOIA purposes, or if there's a court order. So what about our employees? We're all public employees here. Is your information releasable? Is all of your information releasable? Is some of your information releasable?
Son.
Yeah. If you're an undercover cop, don't answer that. Joking. So again, it's going to depend. It really depends on what kind of employee file that we're looking at. There are two types, and the law treats these separately, even though in practice they're usually kept in the same space, right? Your employee file, it's a big folder. You should have it separated, but some people don't, but it's all together. But the law separates these things in two different types of files. One is going to be your personnel record, and the other one's going to be an employee evaluation or performance review. And those have different ways that we look at it, and different ways that we determine if it's releasable or not. So a personnel record, right? That's going to have your hiring documents, your application, your resume, your name, what your salary is, yada, yada, all of these things on here. Not everything is going to be releasable, but a large portion of it might be. The law kind of tricks us with its wording. It says personnel files are exempt to the extent that it would constitute a privacy violation, right? An unnecessary one. That means that most of the time the stuff is going to be releasable. So one of the things that we look at, they're open to the public except for the fact that disclosure would constitute clearly unwarranted invasion of privacy. You've got to assess where the information could lead to that, right? So exempt things, dates of birth, driver's license numbers, social security numbers and things like that, we don't turn that over. If the information could give rise to greater than a minimal privacy interest, then you have to kind of determine whether that privacy interest is outweighed by the public interest. You kind of use that same balancing test that the court used. Why do you think this should be exempt, right? My name probably shouldn't be exempt, right? I don't need to know that my name is hidden. My social security number better be. Because if I find out you throw out my social security number and I don't have a lot of money in the bank, but I like what I got, I don't want that to disappear. So we look at those kind of things. Some releasable information, right? My name, the date I was hired, my education. Now, there are education documents that we don't have to turn over. But just in general, where did you go to school at? That's public information, right? That we don't redact that. Any certifications that I've got, that's telling me what I'm allowed to do, that I'm capable of doing. Your resume, subject to some redactions. Your application. We give out work and email and work phone numbers and gross pay. Now, gross pay is important. Y'all, gross pay and net pay are two different things. Gross pay is my salary before taxes, before anything else is taken out. I'm going to throw out a number. This is not what I make. I'm dreaming big here. My gross pay is $120,000 a year, right? Before taxes pay out. That is releasable, right? That's the baseline. That's saying, hey, here's the public money that goes towards you. But then they take out taxes. Unfortunately, they take some money away, all right? And maybe I get taxes taken out, state and federal. Maybe I pay child support. Maybe I've got a lien that I'm having to pay off. Maybe there's a court that's maybe I didn't do the right thing and the court's taking some of my money out of my paycheck. I know that information. The general public has no need to know that information. That is none of their business. That does not affect my public work or anything else like that. So we would redact that information. Along with any tax stuff, banking info, my marital status. Public doesn't need to know if I'm married or not, unless it's important to some type of public scandal where maybe I'm siphoning off some public funds to my spouse, right? And that's going to be a court case about that. So your dependent information. Public doesn't need to know who your kids are, right? They don't need to know what your social security, date of birth, and driver's license number is. Your private contact information, non-elected employee home addresses, unless your city has a policy that your employees have to live within the city. Now, I've seen this in a lot of cases, right? Some cities do have policies. They want their police officers and firefighters to live within the city because we want the people who are policing our towns to know our towns, right? Small towns, not as much. Big towns, we see this more often, right? We want you to be part of our communities and things like that. If your city has a rule that you have to live within the city limits to work for the city, then that address could possibly be turned over, right? We would argue and quibble about that a little bit, but I could see a court saying, okay, if there's a reason that they need to know that you're actually living outside the city, maybe they can get that. Medical coverage and insurance information we don't turn over. I mentioned earlier that these evaluation and job performance records are actually different things, right? They are treated separately than your employee file, right? Just your personnel file. Hopefully, most of your evaluations turn out good, right? Not all the time, but hopefully that's what happens. These are records that the way that we know that they are what they are created by or at the behest of the city, right? They're created to evaluate the employee. They're created to evaluate the employee by detailing the employee's performance or lack of performance. So if they meet those criteria, they are probably employee evaluation job records. What if this is a citizen complaint that somebody came and dropped, like maybe they're mad at me because I said something they didn't agree with. I said that people might have used the FOIA and they're pissed about that. And they're going to write a complaint to John Wilkerson, my boss, and turn it in. Is that an employee evaluation or performance record? Was it made by or at the behest of my city? I don't think it was. Not unless the city actively said, hey, come fill out this request, right? That could be at the behest. But generally, if this is just somebody giving it in, the handwritten statement, that's going to be releasable, right? But every year, I have a performance review. It's gone well so far. I'm still employed. Good for me. Hope to keep it that way. But my boss comes in and he tells me what I've done right. He tells me what I've done wrong. He fills out a thing and he lets me know how I'm doing. That was made by my public employer to evaluate my performance, and it details my performance or my lack of performance. That is an employee evaluation or performance review, right? And so that's how we know what it is. Now, the other question is it releasable? Do we turn that over, right? And there is a test, right? These records, they only get released. There's 4 things here. So we have 3 things that tell us if it's an employee evaluation or job performance record, and there's 4 things that have to be true for us to release it, right? There has to have been a final administrative resolution. That means it is done, right? If I got, there's no question about it, this is final, that resulted in a suspension or termination, and the requested record forms the basis of that suspension or termination, why that decision was made. And there's a compelling public interest in disclosure, right? So let's pretend I'm notorious for showing up late for work and I get written up for it. All right, that write-up, was it made by or at the behest of my public employer? Yes. It details my performance and it's made to evaluate it. So it's an employee evaluation or job performance record. All right, so somebody wants it. Is it releasable? Has there been a final administrative resolution? Yeah. My boss wrote me up. Good. Was I suspended or terminated? Nope. Not releasable. Yep. You don't give that out. If it did result in a suspension or termination, that's when you release this information, right? The public, that's a major decision, right? That's kind of harsh. And the public has a right to know why, because they're the ones who are paying us. What did I do wrong to deserve to be fired or to deserve to be like suspended for a couple of weeks? They have a right to know that, so they can get that. But again, it has to be final, right? So if you are, does Hot Springs use a civil service commission? Yeah, so you guys have a civil service commission. Maybe, I hope this doesn't happen, but maybe your chief has decided to terminate you, right? But maybe that has to go, you have not gone through your statutorily obligated kind of hearing yet, that public hearing that you get to have to defend yourself. That hasn't been a final administrative decision yet. After your civil service commission does what they do, and if they agree, then that's where there's been a final decision made, right? So has it been final, and has there been a suspension or a termination, and is the document about the reason? So again, maybe I do get fired, right? Maybe I get fired because I came down here and just told you guys what the law was and it's recorded, and I just lied to you. Maybe I just told you don't have to comply with anything. Just go do what you want to do. It's Tuesday. Live your life. They don't need anything. That's wrong. That would probably get me fired because I lied to you all and I am going to get the city sued. So maybe I get fired. But is that right up for me being late for work? Is that the reason I got fired or terminated? Has nothing to do with it. So the reason we allow for this, the reason that the law allows for this, is they want our employers, our public employers, to be able to have some candor when they're evaluating our public employees. If what you have done wrong is not a terminable offense, I don't want somebody, and I'm trying to correct that behavior, right? And I want to talk to you and fix it. I don't want somebody out in the public to be able to get a hold of that record and then come blast you and ruin your reputation. What you did not rise to the level that you do not need to be employed any longer. But we want to do some corrective behavior. You're a good officer. You're a good employee. We just got to fix a few things, right? We want to be able to do that without having our employees drugged through the streets and lambasted for just minor infractions. That makes sense, right? We want to be able to work in that. We also, when somebody's doing something right, the same situation applies. Maybe I get a glaring review and somebody wants to get that. Come ask me. I might tell you to release it, but I might tell you not to, right? I may be somebody who doesn't like attention. I don't want everybody knowing that I'm, awesome at my job. I'm a super lawyer. I'm not, right? I might tell you, don't release that. I don't want people knowing how my evaluation went. It's embarrassing. And then you would say no, right? You could easily do that. There is a little bit more. On either case, whether it's a request for a personnel record or an evaluation and performance record, you have to make the decision within 24 hours whether or not you're going to release it, right? Good, bad, or otherwise, right? Maybe you're not going to release it. Maybe you are. You have to make that decision within 24 hours. And then you let the requester know and you let the employee know, right? Why do we do that? Well, if you're letting the requester know that you're not filling this and that you're not turning this over, that they're asking for an evaluation or performance review, nobody got fired, there's no compelling reason, whatever, hey, this is not subject to the FOI, we're not turning this over. I disagree with you. I have a right to go ask the AG for an opinion. Flip side, hey, you got suspended for 2 weeks because you did something dumb and somebody requested that. I really don't want this getting out, right? You got to make the decision in 24 hours. You let me know, hey, your evaluation is getting put out there in the world. Like, we're going to release it. We got a request for it. That's going to embarrass the dog mess out of me. I don't want the public to know that. So I've got a right as that employee to ask the AG for an opinion. Hey, can you please tell me that this is not releasable? Now, the AG has about 3 working days to respond. Who here thinks the AG responds to every single letter they get in this regard? They do not. In fact, unless it's a pretty clear cut or kind of this big issue that they need to weigh in on and they want a published opinion on, they really won't respond. If it's very simple, they're not going to waste their time on that. If they do not respond within 3 working days, go by your decision. If you have decided that you are not going to release, then don't release. That's when you send the person the requester saying, hey, we let you know in 24 hours. The AG, you sent them a letter. They did not respond. They didn't respond. We're not turning this over. Or, hey, employee, same thing. They didn't respond. We're going with our gut decision and we're turning this information over. But they have a right under the law to do that, right? So we have to make sure that they are able to do that. And really, like I said, that important part is about the suspension or the termination. So let's switch gears a little bit. We got about 20 minutes, and I can speed through this last part because a lot of it's just new stuff. And again, a lot of this is public meeting stuff. Doesn't really apply to you guys. Everybody doing okay, by the way? Okay. So open public meetings, board meetings, council meetings, commission meetings, things like that. There's a new law, Act 605. It's got some new stuff in it, but it also takes a lot of stuff that we already knew that we got from court cases and AG opinions, and it just puts it into the law. So there's not a lot of change to it, but there is some significant change, and we want you guys to know about that. So there's new definitions, and y'all know how I love a good definition. There's also a couple of different things that we have to do now. So a public meeting is now defined as the formal gathering together in a special or regular gathering of the governing body, whether in person or remotely. So a couple of typos in here. It's Act 605, not 505. I don't know why that keep listing 505 in there, but that's what it is. So it took out the word informal. That's important, but that doesn't mean that we get to have just informal meetings whenever we want to and we're good to go, right? A public meeting does not occur also when members of the governing body get together to talk and discuss remotely about a cause of action in a court-ordered alternative dispute resolution. Again, we look at these things. Sometimes you get sued and the court will be like, all right, guys, mediation first, right? We want to do resolution before it gets ours. You guys go talk to this mediator. Maybe they'll work something out. Before this part of the law was passed, our city council had to call a public meeting. How do you guys feel? Do you think it's a good policy if we're talking about a settlement and we have to have the city council say grace over something like that, and we're trying to talk to them as city attorneys? We can't talk to them in executive session, so it's on the record, it's in public, and the city attorney's like, I got to know what the bottom line is, folks. What's the maximum that you'll settle for? And they say, well, the maximum is $50,000. It's an open public meeting. The attorney's sitting right there, or he's having somebody in the audience tell him what your top line is. Are we going to be able to negotiate? What do you think they're going to come back and say? Well, we're going to start. We're not going in. We're starting at $50,000, right? We're going to work down to there. We know that that's your bottom line. You said it in an open public meeting. You've got no negotiation power. Well, the legislature finally realized that, and they said that makes a lot of sense not to do that. We're settling these things that we should let the attorneys work this out. And again, there should be some candor to that. So they've modified the law. The They've also changed the law. I think it is Act 505, not 605, actually, on what a public meeting is and how we hold a public meeting, right? So in order to hold a public meeting, we have to make sure that prior notice has been given. We have to make sure that executive sessions are conducted in accordance with the law. That's not new. That the meeting is recorded, also not new. And that the public has reasonable access to the meeting and the governing body that attends the meeting according with law. None of that is new. It's finally codified, though. We took some legislation and we made it to map out what we knew from court cases and stuff. The city has to ensure that the time and place of each regular public meeting is public, right? And it's available and communicated to anybody who wants the information. This stuff usually gets decided in January, right? Maybe you have new officials, they come in, they hold a meeting in January, they organize the body, they say our regular meetings are going to be on the second Tuesday of every month, right? And you publish that. You put that out there for everybody. Put it on your website if you've got one. Make sure that people know, because they get them in there, that you want to hear from the public on things. We don't keep our regular meetings private. We don't keep them secret. So how do you do that? So unless it's specified law, the law now says that you have to provide notice at least 3 days before the public meeting takes place, right? You have to let people know. Now, this part of the law doesn't specify how. We'll get to that in a minute. But it just says that for your meetings, you have to let people know that you're having a regular meeting at least 3 days before you have it. You announce your full schedule in January for the entire year, all 12 of your regular meetings that you're going to have on the second Tuesday of every month, and it's been at least 3 days before December, you're good to go. You've announced it. You've publicized it. But they've also changed some stuff that we have to do if our city operates a website or social media page. That does not require us to have one. I think you guys do, and so this would apply to you. But if a city doesn't already have a social media page or a website, it doesn't require them to make one. But if you do, the law requires the city or town to publish the time, place, and date of the public meeting on the website or social media, right? You have to furnish the most recent current copy of the agenda to anybody who wants it. And you have to make sure that you have published the current agenda for the public meeting online if the governing body maintains a website or social media page at least 3 days before the regular public meeting and at least 2 hours before the emergency meeting, that if you call for an emergency meeting, right? So all of our meetings kind of have agendas, especially our regular meetings. The city board, in your case, sets those agendas. They work through it, and they usually they know what it is a couple days beforehand, or they're working through a process. You guys have a website, so the law now says, hey, city board, you have to publish the current version of the agenda at least 3 days before you have your regular meeting, so the public can see what's going to be on the agenda. They may want to come in and give comment to it, right? Okay, that makes sense. Are you set in stone, though? No, right? Maybe you have some board members who are like, well, we don't have enough information to actually talk about item 8. Take item 8 off. Your city manager says that, right? And they take item 8 off. That's okay. You can do that. You can fix the agenda right up until the moment that the meeting starts. But you have to at least publish it 3 days before. Or you have to publish it 2 hours before for emergency or special meetings. For special meetings, the law already requires you to give notice to any media in the area, in your county, or anybody who regularly covers your meetings at least 2 hours before, so the public can have a representative there. So it doesn't really change the process much. Now, before you call, I get the papers right across the street, right? I'll use them for a good example. You call them, say, hey, we're having a public meeting at 5 o'clock. It's now 2 o'clock. We're 3 hours before. We're good to go. And then at the same time, hey, publish that on our website and social media page. Good to go. Have your meeting. No issues. So special meetings, again, doesn't really change anything. Still have to make that, notify the press 2 hours. It should sound familiar because it's already been the law. So I mentioned that the law removed the word informal from what constitutes a public meeting. Before this went into effect, and actually kind of now because it's still not in effect yet, I tell people that 2 or more board members, 2 or more city council members cannot get together and talk about public stuff, right? You shouldn't be discussing city business unless you call it a public meeting, right? Even if you don't have a quorum. But they've changed that a little bit now. So these kind of informal meetings are no longer required to be considered public meetings. But if you're talking about city business, it's probably not an informal meeting. So an informal meeting that includes what's called deliberation, or that's for the purpose of exercising a responsibility, authority, or power or duty over the governing body, is prohibited. You can't just use it as a shield and say, well, we didn't declare the meeting, we didn't post or publish it, it was just informal. We happened to meet at the park, we all have grandkids that were playing, and we saw each other, so we decided to go ahead and handle business there. It's an informal meeting. We didn't have to call it. You just violated the law, right? That doesn't work. So even though it removed the word informal, doesn't mean we can have informal meetings. If that's not clear enough, the legislature clarified a few cans and cannots, right? So things that we cannot talk about in a meeting that's not being called, right? You can't conduct polls. Who here knows what a poll is? So what a poll is, we'll pretend like you're the city board. We happen to be at the local football game and we're watching. We're all sitting on the same row. I'm curious. We've got a big vote coming up. How are you going to vote? How are you going to vote? How are you going to vote? That's a poll, right? We can't do that. The law says so, right? So we cannot conduct polls. So I do want to caveat that, though. You can still conduct a poll for administrative purposes, right? We're setting the agenda. I'm the clerk. Board members, here are the agenda items I have on the agenda. I need a yes or no if you want each one. Maybe we have a policy that says that, that's three, each agenda item has to have 3 board members okay it to be on the agenda. Here's what we've got. I need 3 on each one to set the agenda. That's okay. That's an administrative thing. They cannot tell you how they plan to vote, though. All right, we're not talking about that, just whether or not it's on the agenda. It's an administrative thing. We also can't do anything that constitutes deliberation, as deliberation can only lawfully occur at a public meeting. So you might be asking yourself, we just talked about what a poll is. You might be asking yourself, well, what constitutes deliberation? 2519-103 has been amended to include that definition. And so what it says is that now 2 or more members of a governing body that are related, an exchange of information or an opinion between 2 or more members of a governing body that is related to a decision on a matter that the governing body could perceivably take action on. So we're talking about it, right? We cannot do that. What we can do, though, is we can now talk about background and decisional information. And that's going to be information that is information that's not deliberation. It's one of those things that the definition doesn't tell us what it is, but you got to add them together. So background and non-decisional information is any communication that is not an exchange of information or an opinion between 2 or more members of a governing body that's related to a decision on a matter that the governing body could perceivably act on or asks how the official might vote on the matter. So a lot of communication. We're running out of time. Again, y'all have guns and I don't, and it's getting close to lunchtime. We all know what could happen if you violate the FOIA, right? You run the risk of a misdemeanor. You also run the risk of something being invalidated. Executive sessions are very important. There's limited reasons that we can go into executive session. Our governing bodies can go into executive session to talk about employment, appointment, promotion, demotion, discipline, or resignation of a public officer and employee. But that's kind of it in terms of personnel matters. You can also go into an executive session to talk about privacy concerns to a utility, again, critical infrastructure, things like that. Very limited on who can go into an executive session. Your board members, your mayor, your manager, if you have one, can go, well, not your manager, your board members can go into one. Your mayor and city council members, if you're in one of those cities, the employee that it's about, their supervisor, their department head can go in there. And that's kind of it. Maybe an interviewee for a top administrative position, but no one else can attend, including your city attorney. And that has not changed unless we're talking about an deliberation and a settlement for a court order mediation. So we also are now limited on what we can do for attending meetings virtually. Basically don't unless the governor has called an emergency situation. Like maybe we've had a tornado and you need to go into, or maybe we're in the middle of a plague. We've been through one, right? We know what that's like where nobody can go outside. And then you can have your meetings virtually, but wait for the governor to call that. So our meetings still have to be recorded. That recording has to be kept for a minimum of 1 year. The city has to keep it in a format that can be replicated and given over. And importantly, that recording requirement does not apply to executive sessions when we go in to talk about those personnel matters or those public safety matters for our critical infrastructure or our volunteer fire departments. Obviously, I could talk to you guys about this all day. I'm not because we're out of time and I want to go back to Little Rock. I got work to do. But these are some other issues that we face with that all the time, right? Response times, generic request, attorney-client privilege. How does that play in? It usually doesn't. Lack of personnel and technology issues. At the end of the day, what I want you to leave here with is that the FOIA is robust. There's a lot of information. We are bound by it. We have to comply with it. We don't want to get those misdemeanors. But the other part is that we should want to. I know it can be a headache. I know it's hard going through all those records. I know that the public is not generally nice when they do this, or sometimes they're trying to trip you up. I realize it's hard, but I got a feeling that everybody in this room works for the public. because at some level you have faith, right? You have a belief that in our community, in our society, in our cities and towns, you guys don't protect people because you don't like them, right? You guys don't work for the people because you're annoyed by them. We do our jobs because we actually do like the public. We like living in a society. We like it. We like our neighbors, right? Read a good book one time that said, we treat people the way we want to be treated. I like that. And I think that every public servant comes into that. So as you leave here today, you go home to your families, just think about that. If you have questions, my business cards are up here. Please take one, email me, call me. And then last thing but not least, I just want to say thank you. And I mean that legitimately. Thank you for what you do. I appreciate you. I appreciate the protection that you guys give us. I appreciate the hard work that you men and women do. I live in a city. My parents live in a city. My grandparents live in a city. Everything that you do keeps people I love safe. It keeps our water clean, right? You keep the bad guys from getting my folks I love. And I respect that. And I would not work for who I did if I didn't. So thank you sincerely for what you do. And y'all have a great day and call me if you need me.
Chief, you can